Hello, today I'd like to talk about a couple of terms that are regularly used in wills and that we encounter as lawyers that have a meaning or may have a meaning that's different to what might be expected. Certainly in one case, it was an unexpected meaning for me, potentially. The first is personal effects. There was a recent New South Wales decision of Low and Low that considered that term and found it to include a $60,000 Mercedes-Benz motor vehicle as part of the personal effects that were left to a person. That case, by the way, is an excellent summary or review, really, of all of the ways that personal effects and personal chattels and so on have been judicially determined, and I recommend the case to you as a good one to look to when you strike terms such as that. The other area that I wanted to mention, or the other issue, was jewellery. We'd normally expect that jewellery would be something you could wear, but there have been a couple of cases where unmounted loose gemstones have been determined as jewellery so far as the will was concerned. I think therefore that it's very often important to talk about what is meant by jewellery for our clients, whether they have unmounted or unset gemstones, often investment stones, because it can create a lot of uncertainty and certainly the necessity perhaps for an application to the court if those issues aren't properly covered off on. Just two things. I mentioned in my book, by the way, the cases where that jewellery issue is addressed, and it can of course depend on the context. But I just thought I'd mention those two because they're quite contemporary and important. Thank you.